Zoom. Great. Okay. Well, thank you everybody for being here this morning. I appreciate it. So we included in our technical advisory that we sent out yesterday links to the draft agreements. I also have just uploaded them now into the chat for anybody who hasn't gotten them. And so so the goal of the presentation today is to share the documents, review the updates, and how we've responded to feedback received over the past couple weeks, and discuss impact of those changes. And then I have a survey tool to capture additional feedback, and then we can check in on next steps. So thank you all for being here. So the first thing I just wanted to do is regroup around what we have kind of learned and try to clarify over the past couple weeks, which is, so first wanting to think through what it is that the state needs from the investment of Article 11Q bonds in affordable housing. So firstly, we need to make sure that the affordability is not able to be foreclosed. Secondly, we need to have our loan in first position. And while we're able to share first position, our rights need to be established so that we're not being put into a subordinate position within that first lien position. And we are also able to have our loan repaid or satisfied with extended affordability. We also need to have operating controls included that are meaningful. What we heard from lenders about what they need to be able to participate with the state is they need their loan in first position, and they need rights established that don't put the other lender, in a subordinate position. They need to have the ability for all liens to be extinguished following a foreclosure action. And then they need to have the ability to be repaid in a foreclosure before the state, understanding that affordability remains. So it's with those initial tenets that kind of walk through the updates that we have incorporated into this latest round of updates on the draft documents. So first established within here is that our affordability requirements survive foreclosure. We have done so largely through our operating agreement. So we have updated that we do allow and would expect that our lift lien or Article 11Q bond lien is extinguished following foreclosure action. But that in the case of foreclosure, the operating agreement, property management agreement, and affordability restrictions remain. Following initial, without foreclosure, following an initial 30-year affordability period at 30 years, this is consistent with prior practice. You would either be able to satisfy your loan with either repayment or extended affordability. Upon foreclosure of the Article 11Q bond lien, there would be an automatic extension of the affordability terms for another 30 years. And so in thinking back to what the state and lender needs are, this is speaking both to the state need for affordability to not be foreclosed, and the lender needs to be repaid in foreclosure before the state. So these revisions are allowing liens to be foreclosed, but the affordability to remain, and even in the case of the financial foreclosure, would still allow the state to get that loan satisfaction through extended affordability, essentially. The second primary update that we have incorporated, or our council has incorporated, has been to really reestablish and rebalance the controls of all lenders that are sharing first position, so that neither state lender nor private lender are in a subordinate position. And so this did replace the agency concept, which had previously been included in the documents, and instead establishes conditional consent provisions where there are clear guidance and rules about when enforcement actions would be taken, including foreclosure. There's detail on the foreclosure triggers that are within there, really detailed and laid out. There's also what we're calling the escape hatch if both the state and the other lender in the deal agree that though one of those triggers for foreclosure has occurred, they can choose to act differently. So it gives both clarity of where the state would agree to foreclose, as well as provide that escape hatch if neither party want to actually pursue foreclosure. So that update in particular is to speak to loans in first position for both parties that don't put either in a subordinate position within that first position, and for the lender establishes the ability for all liens to be extinguished following a foreclosure action. And again, this is about balancing the rights within that the first position so that neither party is needing to be in a subordinate position. And so the last update is in terms of kind of overall having sufficient controls to meet Article 11 coupon requirements, and allowing that lien to be extinguished, we have to rebalance that by adding additional operational controls. So we have expanded, and this is why in the last update, we only included that priority and subordination agreement and intercreditor agreement. We have now added into the draft updates our operational document, and that is because we have done work within there both to address that long-term affordability restriction that wouldn't be able to be foreclosed on, as well as adding some other operational controls such as penalties for non-compliance and a review of tenant screening criteria. And again, that last piece is to address that we need to have meaningful operating controls within transactions. So yesterday, we met with the lender community and have gotten some preliminary feedback. Obviously, they haven't had the legal documents for very long to review in detail with counsel and get the all detailed feedback from them. But the initial feedback I kind of summarized here is first, they requested that there's just a really more explicit call out and understanding that we do allow the Article 11 coupon lien to be extinguished in the case of foreclosure. And that seems consistent with the updates that we have worked to implement. The second piece there is that within the conditional consent process and detail, there were just some questions about the applicability of those enforcement actions to the lender loan, meaning they really asked for for us to clarify our intent regarding the applicability of those enforcement actions to the lender lien, and what greater flexibility do we have perhaps to allow the lender to have direct, I don't know how the right words to say it, if DOJ has additional insight on how to frame that request, but it was around the rights in that as it stands right now, enforcement actions are inclusive of all resources in the project, and the lenders wanted to have some more explicit controls over their own resources. And so we'll be pursuing that conversation to understand where we might have flexibility and where we would not. And then lastly, there was some expressed concern that we have within these documents. The other lender in first position does not have control over our operating agreement. Again, that is because we are not allowing our affordability restrictions, which are now embedded largely within the operating agreement, to be extinguished upon foreclosure or any other enforcement action. And yet, if for some reason OHCS determined or the state determined to eliminate the affordability restrictions on the operating agreements, we would expect to be repaid for that investment. And I think that is, so that's something that we're working through. And I think part of what I'm curious about doing is looking to use tools like our administrative rules or other to provide either clarity over the terms or the definition by which we would want to pursue eliminating an operating agreement, or probably even better, providing what a process would be to be able to evaluate such a move. And I think to that end, our real objective is to ensure and retain these resources as affordable housing investments, and so would retain affordability in nearly all cases that I can think of, but obviously having some means to eliminate them needs to be feasible, and we need to be able to provide some clarity around what that would look like. And so with that, I think we have created a brief survey. That's the short link. Find that. A short survey to be able to get some input on the updates that we have implemented. I'll paste that link into chat here as soon as I can. Okay. So putting that link into the chat, and then I guess any questions that folks want to talk about or discuss here, I am happy to. And yes, I will. I see the question in the chat, Travis, that yes, I will be certainly sharing this PowerPoint after this meeting. I can direct send, or we can probably upload it to our website as well. Let's say, Jillian, I see your hand.
Yeah, thank you, Natasha, for walking us through those changes. I think it's definitely heading in a great direction. And I was hoping that I could just kind of reflect what I heard you say and make sure that I understand it correctly. There's a lot of like extinguishment and legal terms, and I just want to make sure that my understanding of those legal terms are the actual understanding. So what I'm hearing you say is that in a regular non-foreclosed lift loan, the loan is forgiven, and if the borrower agrees to extend the affordability another 30 years. In the case of foreclosure, that 60-year term becomes automatic, and the lift loan comes off of title. It goes away. So the income restrictions are there, but the obligation to repay a debt is gone. Is that correct?
That is true in my understanding as well. And if any of the legal counsel on this call want to clarify further or differently for me, please do. And so yeah, so I think and I'll just restate it for you in my understanding. So without foreclosure, okay, so we can't give legal, DOJ can't provide legal guidance to us. So, okay, so in the case of foreclosure, okay, without foreclosure, which is where you started, without foreclosure, it's the same as it has been. It's a 30-year loan. You can either satisfy the loan through repaying it or extending affordability for that additional 30-year period. In the case of foreclosure, the lien is eliminated, and the affordability restrictions remain through the operating agreement and other property management controls, and is automatically then that additional 30-year period is added to it. I think that we're saying the same thing. Is that?
Yep, that's how I understood what you were saying also. And then so I think it's great to get the foreclosure, the pro rata share out of there. I think that was a major concern I heard from lenders. Yeah, and I'm curious what the lender reaction has been to the operating agreement persisting after foreclosure, and if that has brought up any challenges.
I mean, I think I have not heard that that concerns about that at this point. So I'll just say what I have heard. And in fact, I think in my initial conversations with them after the first update, there was not an expressed concern that affordability restrictions remain. It was that the lien needed to go away. So it was that the lien was the problem, because having debt be recorded against a project that has been foreclosed isn't didn't meet foreclosure for those parties.
Thank you very much.
Yeah, yeah, and again, we'll continue to round back and get feedback from everybody, but that is my understanding at this point. Hey, staff.
So in the past, I thought LIFT was like a 45 or 50-year term. Are you changing the term to 30 years?
I think there's been some use of 45 and 50 years in Metro where there was a 99-year affordability. And so I think those are project specific. The minimum would be 30 plus 30 at this point in time for state affordability.
Just because a 30-year term doesn't really work. If you think about it, at year 15, when you refinance, you could have the issue where, how do you take out that debt in 15 years, right? So you're going to be in a position that you're going to have this debt on the books that, is going to be shown due in the next 15. You're going to have a problem getting. So I would vote for a 45-year term.
Okay.
Yeah. So longer term works better for soft debt. Thanks. And then you were saying that it was forgivable. Or what was it that you
It's
were
not
saying?
forgive, it's able to be satisfied with extended affordability.
Okay, satisfied with this. I don't know if there's anybody on the phone that could speak to that. Does that have any issues with like demonstrating that it is true debt or anything like that?
I can speak to a previous
Sure,
deal with
Jillian.
that 30-year term and 30-year extension, and yeah, the debt is satisfied, not forgiven. So that
makes the
the difference. Yeah, that's my misspeaking there.
Okay. Yeah. Okay.
Yeah, and I think the specifics of that structure were designed in order for it to meet true debt test, but that I mean, so any of that was an intent. So if there are challenges, please do let us know.
And is there anything with the extension, any conditions or anything that seem onerous or the last thing you want is an extension time that you can't, so trying to, do you know what that looks like or?
I mean, we haven't yet met that 30-year period for any of these projects, obviously, but I think it would be a natural extension, a carry through of existing restrictions and controls. I don't think that there would be anything. There's nothing that I know of that's intentionally different about that period of time.
Okay. Thank you.
Hey, Scott.
Hi, Natasha. Thank you so much for putting this on. It's really helpful. I represent a couple of lenders active in Oregon, and curious if the 60% AMI rental restriction that we're seeing in the operating agreement, is that going to be consistent on every project, or is OHCS's intent to have deeper targeting on affordability restrictions in that operating agreement and on a deal by deal basis? I guess we're just looking for consistency, and when we're talking about any restrictions that potentially survive foreclosure, it's obviously most helpful to have less restrictive restrictions in place that for purposes of ordering appraisals and valuing collateral, et cetera.
So I think that's a great question. I think these are deal by deal, and I also see that our program analyst Becky put one on her camera, so maybe she has some insight to lend into that.
Yes, this is actually something that we do it on our NOFA. In our notice of funding availability, we award points based on how many percentage of 30% units you're going to have. So we do, and if people ask us that, if people are promising us 30% units, then we do put them in the operating agreement. For LIFT, that we do not put them against the LIHTC or the bonds. We just do it against the lift affordability.
And is HCS willing to explore any sort of load up of those restrictions where we're still affordable, but those would float up to 60% AMI if there's a lot, if a deal has project-based vouchers and loses those subsidies, or if there's a foreclosure where, understanding and recognizing OHCS's needs to keep the project affordable and promote long-term affordable housing, but complying with kind of less restrictive restrictions in such a scenario like 60% AMI.
I think that we're willing to have those conversations on a project specific basis, and Becky, certainly if you have other input, please.
I think that this would be a discussion for internal and DOJ. So I need to run that by everybody else. So, but I have heard that I know Portland Housing Bureau does allow their affordability restrictions to roll up to 60%. So I do know that there is verbiage out there that we can use. I just need to make sure that that is consistent with what our policy and planning and DOJ teams want.
Understood. We greatly appreciate your consideration of that, because it's a pretty important part of the underwriting analysis in order to get the credit approval that's required for unsubordinated restrictions.
I do want to point out that Lyft rental only allows us to go up to 60% AMI, so we would never go up to 80% AMI at this point.
That would be the bounds of that. And so, yeah, I appreciate the highlighting the question and the need there. And speaking of Portland, Jill.
Hi, Natasha and Becky. Thank you all so much for having this conversation with all of us. I did want to just check in because in an event of foreclosure, it is usually that, the revenues are not enough to support the loans or support the operations. So in an event of foreclosure, if there's no change in the, call it the rental rates, so to say, to get this project right-sized, I really appreciate the fact that you would like to continue the affordability. As you all know, we have a 99-year affordability, so we're in it too. But it seems like by capping, like Scott said, the ability to float up, the ability to restructure this whole project may be called into question. So I really hope you and DOJ would be able to find a way to resolve that. And for those that are 60% units, understanding the requirements of the program, it could be sometimes really difficult, even for 60% units, to maintain operational stability. So I really appreciate you all thinking about that. A second question I have, if I may.
Absolutely.
In the previous slide, and I haven't looked at your current documentation, there was a question about agency and the agency role. Has that shifted and has that completely been removed in the new documentation?
Yeah, and so and I see DOJ has their hand raised. Christy, you're welcome to speak whenever you want. So the prior concept of agency that allowed the lender to act on the state's behalf to eliminate liens, that has been removed for a conditional consent process. In as much as enforcement actions are defined, the triggers for that, including very specific detail about foreclosure triggers, are laid out where the state would agree to do a foreclosure action, and then also gives that escape hatch if both state and private lender want to do something different. And I think I am interested to continue the conversation around what happens with those restrictions in the case of affordability, and as you guys are describing, right, that it's financially insolvable, that it needs some remedy. And I think my instinct is to say absolutely that's the case. We would need to work with the project find a sustainable solution. So I mean, and that's where, and I think Jill, you understand also as another public funder that there's that, you know, you need to balance those and those needs, and certainly wouldn't want to be putting a project into a position where they're just continuing to not be able to be solvent. And you know, whether that needs to be up on the front end with, I mean, what those world of options are is maybe a strategy versus an automatic trigger of something or different. I think as we, you know, our asset management group works really engaged with projects that are struggling and to perform financially, and those workouts include, you know, changes to some of those restrictions to make sure that they have a real viable path. And so I think that is a commitment. Making that a legal commitment is the second question, but I think it is, as a steward of resources and wanting to ensure serving Oregonians, that is kind of part and parcel of our core business strategy.
Thank you.
Kristen, did you have something to add?
I do. Thanks, Natasha. Hi,
Yeah.
everyone. My name is Kristen Galino, and I'm the attorney in charge of tax and finance within the Oregon Department of Justice. So we are the primary contact counsel for Oregon Housing and Community Services. And first of all, I want to say thank you to Natasha and her team for putting on this great presentation and for helping us to work through and understand all of your concerns and feedback from the last round of document drafting. And thank you to all of you for attending today, and also for providing so much feedback and helping us to move the needle to the point that we have up till now. I will say that the easiest way for us to be able to respond to, so first of all, we can't really respond to questions in this kind of forum. So the best way for us to kind of move forward in this meeting, I think, would be for you to continue to provide feedback for us on sticking points or pinch points that you see, and also to continue to communicate with OHCS related to anything that your council says, anything that you go back in your own groups and talk about. And I think rather than engaging in kind of hypothetical conversations and situations, because, as a lawyer, those are my favorite thing. And I could come up with a million of them. I think the best way for us to move forward is probably for us to, on our end, kind of put our noses to the grindstone and start to work on some of these deals that are set to close this next month. I can't believe we're already saying that May is next month, but there we are. And your feedback and thoughts between now and then will be super valuable in helping us to ensure that the place that we get to is workable. Natasha, did you have anything else? Anything else?
No, I think that makes sense again. And I realized I never actually put the survey link into the chat because
yeah, that's one of my favorite parts. Seeing what everybody else will say.
Yeah, exactly. I did just for everyone, unless you're not, in case you're not watching the chat, I did put in there, I've just uploaded a PDF of the presentation I walked through this morning. We'll also make sure to get it up on our website with our engagement materials, and let me know if you needed anything else. But I just did put that link to our a survey. It's a quick survey, it kind of walks through the different core components and has you give feedback to it. We'll also take all of the feedback put into chat and that we've talked about today. And yeah, so I think providing feedback and input is going to be critical to be able to move through these next steps. And in the meantime, I'm happy to just chat about thoughts that folks are having right now. Travis.
Yes, I'm curious if you can reiterate a little bit or clarify a little bit more the conversation around escape hatch. And admittedly, I haven't dug into language if it's in there in the documents. But when I hear escape hatch and the way I heard you describe it, it felt a little bit like, well, this could happen or this could happen. There were some options. And I think one of the things that's important for us as sponsors and developers, and even more important for the lender investor partners, is real predictability in this worst case scenario. And so I'm curious if you can provide a little bit more detail about sort of what that escape hatch is and sort of what sorts of timelines or triggers are in there to ensure that predictability. Because I imagine many of the things that an escape hatch might consider are things that, like you and Jill were just talking about, in terms of, as public funders, you're going to be looking of ways that you can help solve the problem before it ever gets to a foreclosure. So what's different about the escape hatch versus the things that would happen in foreclosure, and how is predictability ensured there?
Natasha, I can take this one really
Thank
quickly.
you, Christy.
Yeah, you bet. And I will reiterate that we can't really answer legal questions here, but I think this one's pretty, I think this one is a terminology thing. So basically what the escape hatch, and that's obviously not the term that we used when we drafted the document, it's if both parties decide that they do not want to foreclose, when the automatic foreclosure options have been triggered, when something has happened to trigger automatic foreclosure, if the lender and the state get together and say, we really think this project is salvageable, and we don't want to be forced into foreclosure, then the parties can agree not to foreclose. So that's all we're talking about with regard to an escape hatch. It's the ability for the parties to agree not to trigger that automatic foreclosure.
But both parties would need to agree. It couldn't be unilateral.
Correct.
Yeah, and I'm just gonna go rogue here. So I think and to that predictability, Travis, I think that's kind of exactly what the conditional. Okay, so in my mind, that's what the conditional consent does. I mean, so you can see, as I think I'm sharing my screen here, that there's underneath this joint foreclosure strategy, there's all of these very specific criteria or scenarios like created and established that would say when is foreclosure going to happen. So like to that point of predictability, and then with, of course, the whatever the right words are for the escape hatch, which is anyway. So that is hopefully the idea of that conditional consent, is to allow that same predictability without the agency concept. Any other questions or clarifications that folks are seeking right now?
Or more feedback if you see pinch points. We had great conversation with the lenders yesterday. And I appreciate Natasha adding that to this slide, because I think it's helpful for everyone to see kind of what minds are headed in the same direction as yours.
Natasha, it's Catherine Shaw.
Yeah, hi, Catherine.
Hi there. On that point of the lender's input,
Yes.
thank you for reiterating what we raised on our call. I just wanted to clarify on the first bullet point in that slide that, and maybe this is what you were thinking, but what's critical in that extinguishment is that upon foreclosure of the bond lien, that the lift lien is extinguished. That's what's critical to us, to the lender team.
Gotcha. Yes. Yeah. And I think I understood that, and I raised it a little awkwardly in the bullet.
I thought you did.
Right.
Yeah. And then, of course, the other two bullet points we talked through on the lender call. And I know that you're thinking through those.
Absolutely. And I guess, and that since we have the minute here, you know, in terms of the operating agreement and the, you know, if it is extinguished, the idea that this, you know, and again, I think it would be an incredibly rare situation where the state would choose to eliminate our operating agreement over a project. But I also know that when we do so, it becomes a market project and a market valuation versus a restricted valuation. And I'm just curious, and you don't, if anybody is on the call is comfortable speaking to whether that shift and that distinction is meaningful in thinking about pro rata repayment, or it, you know, what is the potential for consideration of as to the impact of removing those restrictions on valuation?
I can jump in just, you know, and then I appreciate any other lender, true lenders, not just their lawyers, jumping in. I think that is still, I don't think that really helps their underwriting, because they aren't going to be able to get it underwritten on a loan to value basis, covering both pieces of debt in almost any deal I've ever seen. And so even if it went to market. So
Okay.
I still think that's going to be a problem, but I welcome any lenders sharing their thoughts.
Anybody else have thoughts or input on that? You're also welcome to follow up, either reach out to me or give an input into the survey. Shell?
Yeah, I would, I'm a lender with WaFd Bank. I would agree with Catherine. Typically, our loan to value, it probably isn't going to cover that if we were looking at it for market and including the lift loan.
Can you reiterate that scenario again? I'm sorry, I was taking notes and apparently wasn't multitasking well. I didn't track that.
So I'll give it a shot if lenders or others or DOJ wants to clarify for me. So all the affordability restrictions remain. And so we put into this, the conditional consent process for enforcement actions that the other lender in first position does not have the ability to eliminate our operating agreement. That's how our affordability restrictions remain. OHCS or the state has control over our operating agreement. The other part of that is if there was a situation where OHCS chose to eliminate our operating agreement, and therefore all of the affordability restrictions, both the initial 30-year as well as any potential extension of that, we are there's either you're repaid for it or we have affordability restrictions. So if it did end up foreclosing and we eliminated operating agreement, we have established that we would need some pro rata consideration of repayment. I guess pro rata is the consideration for repayment. And the lenders are, what I'm hearing from the lender community echoed in this conversation is that and so I was asking, essentially, once those affordability restrictions are released from a project, then we are essentially moving it into a market valuation. And does that have an impact on whether there's concern about pro rata repayment? I don't know if Catherine, if I summarized that.
Yeah, I think you did. And I think what we're just responding by saying the pro rata sharing probably still doesn't work for the banks, even if it went to market rate.
Because it's the upfront underwriting.
Right.
That probably wouldn't it be distinguishing the market valuation strategy from the affordable? Or does that change in valuation potential not have an impact? Right, without the affordability restrictions, you can go to market rents, you can do all of the other, have higher operating like revenue into the project.
Yeah, I just think they would have to do a credit underwriting analysis showing that they have to share the proceeds, that they aren't going to get all the proceeds, that it has to cover both pieces of debt. And whether that would work either on an affordability basis or on a market rate. And I think it still in most deals won't pencil out even if you could go to market at that point. And of course, they have to do that analysis up front, right? Before the deal.
Right, at the
goes.
start, not as that happens.
Right.
And I mean, so it is, I feel like I'm wanting to figure out what the strength, like what it is that would actually give more control or certainty around that. And yeah, anyway, I will continue to discuss it and follow up, but we'll noodle on that. But definitely any other input on that question or others? Jill, did I see you come off mute?
Yeah, Natasha, it sounds like for the underwriters and the lenders, the difficulty is doing this kind of analysis upfront. But can I just ask, in an event of foreclosure, does the LIFT program require that you give the option for the loan to be repaid? Or can you just say it automatically converts? Because it may be easier. Maybe I'm asking the wrong person. Maybe I should be asking Catherine. Is it easier for you guys just to assume that you can't foreclose it and you're at 60 years then? Because
yeah, I think what we built in is really, in a case of foreclosure, the lien is extinguished and we go from 30 to 60 years on that loan. So the question, this piece is, that's all assuming that we don't, I can't even think of what the detail of the situation would be, where we would say, you know what, we are going to release all restrictions from this property. We're just going to go in a totally different direction on this. And then it goes through foreclosure. Our lien is extinguished, our operating agreement are extinguished, and then we would want to have something repaid back because we're not getting affordability. We're not getting anything else from that initial investment. And so I think, like, again, so it's that probably 0.0 whatever % chance of that the state would take a stance to remove the operating agreement. But what that provides the lender now is some vulnerability, knowing that we have control, we have the ability to do such a thing, and that would then impact what needs to be paid at a foreclosure. Because otherwise, assuming that operating agreement persists and the affordability persists, which is exactly what we would expect, we would have the other lender paid back first, and we would get the additional 30 years affordability.
I just wanted to echo some other sentiments that the survival of affordability restrictions is something that can be underwritten pretty easily up front. Well, not easily, but we get an appraisal that shows those restrictions surviving for 60 years, including any float up that OHCS considers putting in. And that will dictate some loan to value, and that will dictate some loan sizing considerations. And all that information can be disclosed as part of a credit approval process. And lenders can get comfortable closing the deal on that basis, understanding that if we were in a foreclosure situation, OHCS gets to keep its restrictions and the lender gets to, have priority of repayment on its loan. Having that potentially, the concerns would be either A, if there is, discretionary approvals on OHCS's side that prevents them from exercising remedies in connection with defaults under their loan, or B, if there's a way for OHCS to pull the rug out from them and attempt to have the restrictions go away in a way that denies the bank away from realizing on its collateral. Because at the end of the day, the bank in a foreclosure scenario does not intend to own and operate it long term. They intend to sell to someone in the business of owning and operating housing, affordable or market rate or otherwise. So
Okay.
that's I think how my clients would view this. I'm not sure if anyone, any lenders are on the call feel the same or different.
Anyone else?
I mean, Scott, this is Catherine. I agree. That's essentially what I'm saying. We can't have the uncertainty that unilaterally, we would have to share the proceeds down the
Yeah.
road. But with OHCS being able to say we're terminating the restrictions and now we have to share the proceeds. I know, Natasha, you're trying to figure out a way we could give certainty around that. What would trigger the termination? But right now, that would be a problem for the lenders as currently drafted.
Okay, wait, yeah, which is very helpful to understand those dynamics and what your underwriting process looks like in that vein. Steph, I see your hand.
Yeah, thank you. I guess, what I'm hearing is, and I don't know if I'm hearing this, so I just need clarification. So with this scenario, and I don't know if Scott or Catherine can weigh in, here I am early in concept, going to submit an application for lift funding, let's just say speculatively. How would I work the mechanics to know on the front end if on the back end this is going to work? Would I have to go and get an appraisal ahead of time? What types of things would we have to do to be able to really know if we have a viable deal? We certainly don't want to create a situation like that. So I hope the answer is no, you wouldn't have to do that, because it's pretty onerous. And as we know, early on in concept, things shift and moved, and you certainly wouldn't want to have to take on the kind of that further analysis and due diligence.
This is Scott. I think the largest impact would be on, if you don't have an appraisal up front, you get, the lender, once the deal's signed up, gets the appraisal, they get the analysis back, analyzing these restrictions surviving for 60 years and not terminating in a foreclosure analysis. And that impacts loan sizing. And then you have a gap in your budget because you were expecting to get X million dollars of perm loan proceeds, and now with the underwriting of that, you're only able to get Y million dollars of perm loan proceeds. It's a really project specific analysis based off of the restriction, how many units are impacted, what affordability levels would be in place in the foreclosure scenario. So it's hard to anticipate every potential contingency up front.
Yeah, and that I think is probably, from a developer's perspective, very, very challenging. It's not typically what we do in our industry on the front end that early on. So it's going to be hard to set yourself up for success if there's this added layer of complexity and analysis. You don't know how to size your debt, basically. And, there's a lot of levers that change in the deal throughout by the time you get to close. I just worry if we're creating a scenario where you can't really properly underwrite on day one to know what your real gap is, to know how you get to the finish line. Thanks.
Thanks, Steph and Scott. We'll see Mike.
Hey, thanks, Natasha. I had two non-technical questions that I'll ask of Oregon Housing, but maybe it's kind of more of a general question for the lending community as well. The first is, can you give some guidance on what the department's thoughts are around timing and process for this coming to a conclusion? And second, have you heard, or do you have a sense of what impact these changes will have on the cost or availability or access to capital in Oregon?
Okay, so to the process question, so I feel like this latest round of updates got us very far toward addressing the balancing state needs and lender needs. I think we have these couple, I think they are, as we're continuing these conversations, it's starting to crystallize. We have a couple key key critical pieces that need to have consideration and understand where we can continue to push and where we have some room here. I mean, all of our intent and I just want to, I guess I should share that, Department of Justice has been working around the clock to understand, dissect, and push into these documents everything that to be able to resolve these. So I'm really appreciative to their efforts to do so. We are, I think, all very committed to making sure that we have a viable program to be funding the transactions that are anticipated to close in May. So at some point here, we'll kind of regroup around the feedback that we're receiving this week and makes probably potentially another, can't make any firm promises, but I think likely we'll have some additional changes to the draft templates and then start moving them into actual transactional conversations and make sure that we have something that is workable and viable. And so I think I fully expect that we'll be able to close the May transactions with updated documents. We will likely need to do some administrative rule updates. So I'm going to plan to bring those to the May Housing Stability Council meeting for council approval so that we can move forward with those. We have, a couple, I think it's, crystallizing, there's a couple of these key pieces where we need to continue to have some more conversations and engagement. And I can't remember what your second, the access to capital in the state, is that where you're referencing?
Yeah,
and are
so I
you
guess I heard
thinking
you
about Q bond or leveraged lender debt?
I'm thinking about conventional lenders' participation in LIFT or PSH transactions. And I guess there's a threshold question about, do you think that there'd be some banks that would just not get comfortable with what the final resolution of these changes are? And have you heard anything about lenders pricing these deals differently? That they look at these projects and internalize a different risk profile and decide that these deals are going to have a higher interest cost than a non-Q bond deal?
Yeah, and I guess I haven't heard final verdicts. I have heard that what we had, that first round of updates was not viable for lenders, and so that would certainly have impact to lending. I think we are, continuing the conversation to make sure that we get to something that is workable. And I guess I won't promise that all lenders will decide to participate, but I'm hopeful that it would be, that the majority would, and be able to have, establish an updated precedent for that. And I guess I would defer if there's, I don't know that we know yet what the final impact will be and whether there'll be different consideration from lenders about that. Any other questions? Yes, we're also approaching time here. So again, I'll just put back into the chat, remind you all of the survey. Please make sure to provide any additional feedback. I'll carry through the feedback that we've discussed today. Certainly feel free to provide more examples or questions in the survey and feedback. We'll be regrouping with our lawyers and processing and strategizing to find our next steps here. Really appreciate everybody's thoughtful engagement and feedback as we have these conversations. And I will make sure that this recording gets posted to our website along with the PowerPoint materials, which I also shared in chat. But thank you so much. And I hope you all enjoy the rest of your Thursday. Thank you.
Thanks, everyone.
Thanks, Natasha.